Good evening and welcome to Be Informed. My name is Karl Hariwala and I founded Be Informed to help people make good decisions. Today we're joined by Paul Cott of Law and Lydiard, who will be talking to us about employee rights. Before I proceed, I would like to acknowledge the traditional owners of the lands on which we meet today and pay my respects to their elders past and present. Today's topic is being presented in relation to the Australian jurisdiction. So if you are looking at this presentation from a jurisdiction outside of Australia, you will need to reconsider its applicability. And the information presented today is current as of this month. So if you do check in the future, please do ensure that you check the currency of the information, as the laws in this country do change over time. From a housekeeping perspective, if you do have any questions, please do not hesitate to relay them through to me, and I will answer them, and I will then relay them to Paul for him to answer during the Q&A session. The seminar will take about 25 minutes, followed by the Q&A. And Paul has also kindly prepared a one-page handout, which we will share with registered participants following the closure of today's session. So I apologize for the delay with the starting of today's session. There's just been a few technical difficulties. But without any further delay, I'll now hand over to Paul. Thank you, Paul.
Thanks, Carl. So we're looking at these new laws which passed on the 26th of August for some employers, which is the employee's right to disconnect in Australia. When I say some employers, it means that the small business employers are not impacted by these new laws yet. We'll get to that shortly if we can go to the new slide. The next slide, sorry. Which is, what is the right to disconnect? And I'll actually start off by saying what it is not. What it is not, and because a lot of people might think that what it is that it is not a right to just do no work after hours. An employee cannot reasonably say, now that there is a right to disconnect, 5 p.m. comes around on a weekday, tools are downed, phone calls are not answered from the employer, that is, or the clients, text messages are not answered, emails are not read or not answered or not actioned or anything like that. It is not a right to just do no work after hours and or not to be contacted at all after hours. There's with any new laws that come into play, there's always going to be a lot of talk about how they're going to operate in practice. There's a lot of speculation. There's been a few podcasts where people have talked about it, how it might operate in practice, and little intricacies such as, well, if there's a right to disconnect and the employee doesn't answer it, well, either he did not see it or he or she did not see the communication, or they're just exercising their right to disconnect. So there's no response and the other party doesn't really know what's going on until at a later point in time, which may be too late to undo some damage to customer relations of a business and so forth. So as the slide says, though, it is a right of an employee to refuse contact via any form of communication, so all the social media channels, emails, texts and phone calls, and also any workplace messaging system, to read or respond to contact from employers, clients and or other third parties outside their standard working hours. It is a right that has already been written into many modern awards, and the Australian Fair Work Act, Section 33M, and is probably only a matter of time, unless the government change hands at federal level, before it is also a right put into enterprise agreements and finds a way into employment contracts. I heard the other day that Peter Dutton, the opposition leader at the federal level, has already flagged that he is going to dismantle these laws. So that'll be very interesting. So watch this space. The right will not apply to all employees because some industries, by the nature of the work, there is no work outside working hours. And it will not apply because it's not reasonable for these employees to exercise the right to disconnect. And that is employees who are paid to be on call They will receive an on-call allowance, and also people who get paid who will work occasionally after hours. It also won't apply to many people in senior positions who obviously, as some of us know, are not paid to work a certain amount of hours, but are paid to produce a result or to do a job. So the right won't apply to many senior staff and managerial staff as well, who are expected and or required, and in fact, that might even be in their employment contracts, that they will work after hours at times. As the last point in the slide says, the right to disconnect functions differently to the right to refuse overtime. Although they sound very similar, and there may be some overlap, and it might be that the right to disconnect is a right to refuse an overtime. The right to refuse overtime is really a right on an employee to refuse anything beyond reasonable additional hours and anything beyond what has already been agreed. The whole idea about overtime is that the employer and the employee both agree for it to happen. One can't hoist consent on the other one. And again, as we noticed, when I said that the overtime, in respect of overtime, the employee has a right to refuse working over and above reasonable additional hours, that is the flag that is to these new laws, the right to disconnect, where the word reasonable becomes critical. The word reasonable has been described in layman's terms as how long is a piece of string, leads to much uncertainty, but it is very important in these new laws, because whether somebody exercises the right to disconnect in a lawful way depends on whether that right has been exercised reasonably. The next slide is headed up, can an employer refuse? That actually should be, can an employee refuse? And as I've said there, it depends on the circumstances. There's no one factor alone or one fact alone, but a range of factors that will be considered. And the things that would be considered if it went to the Fair Work Commission, and it is a view of me that these matters will not be heavily litigated in the Fair Work Commission. But the Fair Work Commission, in reality, if or when these matters get there, will potentially consider anything without limitation to come to a correct and just decision. As the second point on that slide says, it is a matter, as many employment law concepts are, a matter of balancing out the employee's right to not work outside ordinary hours against the employer's right to run their business as they see fit and as required. And it's got to be acknowledged that emergencies do occur in a business. They can be created, for example, often by urgent client requirements, which things need to be done, or there will be significant consequences for the client or for the business, such as, hey, we've got a machine that's leaking, can you go in? There's nobody else that can go in and fix it. So an employee is then asked to fix it, but whether he takes the call or not, and whether he's supposed to take the call or she is supposed to take the call, can depend on whether they're reasonably exercising the right to disconnect. The employee may see the call from their employee coming up on the phone, and the employee says, well, I'm exercising the right to disconnect, and I'll tell the employer that tomorrow, but I'm not going to answer that call, excuse me, for a range of reasons, such as childcare commitments, sporting commitments, I'm just at the gym, various things that employees do after hours that would be highly inconvenient, even if not impossible, for them to drop what they're doing and then to do a work-related contact or communication or work-related duty. It has to be acknowledged that work is only one aspect of an employee's life. I heard a podcast this morning, I don't remember which one it was, but the amount of unpaid overtime that Australians work, or additional hours that employees do not get paid for, is staggering. We obviously, work-life balance has become a bit of a term that many people bandy around and many people are not in favour of. However, it is a thing, and work-life balance contributes to occupational health and safety for all concerned. So as we said there, the factors that have been listed in the legislation for to be considered as to whether a refusal to do work after hours is reasonable or not are, as we said before, whether the employee is getting paid for it. So if you're getting paid an on-call allowance, it would probably be a pretty rare case where the employee can refuse contact, unless the contact has occurred many times and it's now becoming unreasonable. Balancing against, as we said, the employee's commitments and responsibilities they have outside work, the reason for and the urgency of the contact, and I submit that the Fair Work Commission would also look at who's made the contact. They will also, though, look at how the contact was made, how intrusive it was to the employee, the employee's job description, obviously what the employee does by way of his or duties will become critical. Level of seniority and responsibilities are always going to be important to look at. As we said before, the higher the level of seniority, the harder it may be able to be justified that the employee is exercising a right to disconnect reasonably. And as we've said a couple of times, any other factors that the Fair Work Commission would determine over time, which may well be, as much of the law is determined by legal precedent. Precedential cases that have gone before where certain factors have been considered may well be looked at as important factors in other cases. So now we're on to the next slide, which is what happens if there is a dispute. Disputes will arise, there's no doubt about that. Employees may get gung-ho and say, I've got a right to disconnect and I'm going to ignore and not even read, let alone respond to, all after-hours contacts. The unions may suggest that that could be the case, and in some cases that would be reasonable. So disputes will happen. What I recommend that all employers do now, or particularly non-small business employers, which is anything above 15 employees, is to have a discussion with their employees as to what is going to happen surrounding these new laws. They do apply, they're in place, and they have been operating for, 2 weeks and a couple of days since the 26th of August. So they are the law now. As we said there, the open, honest, transparent discussion between the parties is always encouraged. Nothing beats that. Policy documents may well be useful. It might even be that some existing policy documents of the employer do deal with matters such as contact or work outside hours. So they may deal with similar situations and or can be amended over time to deal with the new laws. But there's nothing will replace open, honest, transparent communications between the parties. There's no doubt that matters will not be resolved at the workplace level. When these new laws come in, it's probably a bit of a slow burn as to how many cases and how quickly they get to the Fair Work Commission, but there will be cases, just like when they brought in the new laws surrounding stopping sexual harassment and stopping bullying in the workplace. Matters did start to trickle through and have slowly but steadily increased over time. So either party, that is the employer or the employee, can refer the matter to the Fair Work Commission for them to have a look at it and the Fair Work Commission to assist. And as the last sentence there says, the Fair Work Commission has a wide range of effective dispute resolution mechanisms, such as conciliation, and I'm only talking in the unfair dismissal jurisdiction. The conciliations have very high settlement rates. Conciliation is basically a mediation, but with the independent third-party facilitator being an expert or a person who has knowledge and experience in the area. And if the Fair Work Commission deems it appropriate and subject to the parties' views, there may even be an arbitration, which is not a court determination per se, but where the Fair Work Commission can make a legally binding and enforceable decision that can actually be enforced. Now, probably a common question that employers may have is, what if I make the contact after hours with the employee and that contact was unreasonable? An appropriate court, so not the Fair Work Commission, but an appropriate court, if it got to that level, can impose fines on employers if they breach these new laws. So it is important for employers to be aware of the potential for fines, but in my view, they don't need to be alarmed. I just don't think these new laws, if they remain that is, are going to have a very significant overall effect at all. Contrary to what has been flagged by some commentators in the media, some radio stations have said that it would be the biggest change to employment law in decades. With respect, is absolute garbage. I don't think that these new laws will have anywhere near the significant effect that's been flagged. The next slide talks about, yes, when does the law come into effect? So for small business employers, as we've said, an employer with 15 or less employees, they have a grace period. They have another year before these laws will come into effect for them. For them, for the employees to be educated and to have any systems and processes set up in that period. So from about 26th of August 2025, the new laws will come into then. There can be some complexity around some workplaces as to how many employees are in a particular business. The example that I have is that where you've got a franchise real estate agency, for example, where the franchised local business may well have 3 to 4, 5, 6, 7 or 8 employees, but the wider franchise group may have many thousands. As we said there, for all other employers, the new laws are in effect now. There has been advanced publicity about the new laws. From an employment lawyer's perspective, I don't think there's been a lot of publicity, to be honest. I think it could have been wider. That's just my opinion. However, because the new laws, probably for the first 2 or 3 years, will be viewed by the Fair Work Commission, if it came to that, as relatively new. The Fair Work Commission is going to give parties some leeway in respect of their compliance. I don't think they're going to be coming down too hard on employers or even employees if the employees were to deem to have unreasonably refused disconnecting from work or communications from work. So we're on to the next slide, which is, are employees protected from adverse consequences? So obviously the question here is, if the employee exercises the right to disconnect or not to be communicated or not read or respond to contact or attempted contact, is the employee going to be sacked? Are they going to face a disciplinary sanction? Are they going to face some other detriment? They're real questions. The first one can be answered partly by what is in the second paragraph there, and that is, it would not be a valid reason to terminate an employee's employment because they refuse to read, respond to, or deal with contact or attempted contact. But critically, at least where that refusal is reasonable. Now, at first instance, the arbiter of that decision as to whether the refusal is unreasonable is going to be the employer. It will likely be that much of the disputation in such a case will centre around the words reasonable and unreasonable and what they mean in a specific context. Secondly, in respect of employees, they may be happy to hear, and that is that every employee in the workplace has a broad set of general protections at work which have long existed. The general protections such as the right to exercise a workplace right to make a complaint about your employment, such as raising issues to do with alleged underpayments, or I'm not getting my holiday pay, I'm not working in a healthy and safe work environment. All those protections have existed for a number of years, and now added to that is the exercise of the workplace right to disconnect. And that legal right is, as the slide says, without having adverse action taken, which broadly means any action to an employee's detriment or disadvantage, taken against them unlawfully. So if an employee was to exercise the right to disconnect, that right has been exercised reasonably, so determined by the Fair Work Commission, and some adverse action is taken against the employee, such as disciplinary action which is not warranted, or because the employee, or has terminated the employment of the employee, that would be unlawful. Now, I think we've come to the end of the presentation, Carl.
Thank you, Paul. Had a few issues again.
Yeah, I noticed that. It sort of threw me a bit,
Yeah.
but we pressed on.
That's it. No, thank you for pressing on. That's good. This is, I think, the nature of a technologically advanced society. There's going to be the ups and the downs.
Yeah, that's right.
And let me just try and get the deck back up. But that shouldn't stop us. So thank you, Paul, again for presenting on this new regime. I think, as you've said, the regime definitely will offer a new perspective on the right, but I think overall it's not going to have a really big change, given just how business operates in this day and age, right?
Yeah, there's at least one media radio station and another guy who does a podcast who's very employer centric. Have both, I won't name names, have both way overreacted to what these laws are going to mean. It's just fear mongering, to beat their own drum.
I think it is. I think with the whole flexible work environment nowadays, I think employers do offer quite a degree of hybrid working options. So to really say that you're going to be only connected for a certain period of time and then going to be disconnected outside of those hours is probably a bit fanciful. Anyway, the slides are not coming back up again anyway. Why don't we just ignore that and let's just jump straight into Q&A, Paul. So just as a reminder, this session is being recorded. So if you have joined late, don't worry, you can watch this session after today's session on our YouTube channel. And Paul has also kindly prepared a one-page handout, which I'll send to registered participants so that you have a document handy on file, which summarizes the points that Paul raised in his seminar today. So Paul, let's just jump straight into some of the questions that we've got ahead of time. One, I think this question has come from an employer who probably wants to know more about what's your view on them operationalizing this new right? Should they be considering reviewing their processes and policies around engagement after hours? This is something that needs to be sort of done ASAP. Of course, they've got a grace period, but should they be turning their mind to it sooner rather than?
If they got more than 15 employers, the laws are in effect now. There's a potential for fines, and they're pretty significant. But it is my strong view that that they shouldn't have a chilling effect. Employers shouldn't stress about it too much. Employers should be looking at it though. They should be looking at the issue and thinking to themselves, well, how much after hours work do we require employees to do? And how much flexibility do we need to have? Discussions need to be had. I think employer representatives need to chat about the situation. HR needs to be in the conversations, and then employees also need to be in the conversations at the end once the employers have got all that got down pat. I think the most critical, important thing for an employer to remember is that they can still make contact with an employee after hours. The issue then will be, well, what does the employee do with it? And it's on a case-by-case basis. There'll be cases where an employer has sent an email to an employee. The issue will be either the employee has read it and actioned it and or responded to it, or the employee has read it and is not planning on actioning it or responding to it tonight or now, maybe doing so in the morning. So what I'm trying to say is there's a lot of potential things that can happen as a result of the contact. So if you're an employer, don't be afraid to make the contact. You're not going to get penalised for making the contact. It is then, I guess, the ball is in the court of the employee as to what they do with it. After that, if the employer says that after the event, well, that refusal to read, respond, or deal with it was unreasonable, then it may well be that the employer says, well, look, I'll let you off this time, but after this, if I want contact after hours, then it may be that I deem a lack of responding, reading, or refusing to respond to that contact is a lawful and reasonable direction, which is, if ignored, may result in disciplinary sanction. But again, unfortunately, we have some laws that centers around those magical words which allegedly law love and which many people hate, and that is reasonable and what is reasonable. What is
Mm.
reasonable and unreasonable. That's where the kicker is, that's where the uncertainty is, and that's where a lot of the criticism that's been talked about these new laws is placed in what's going to be reasonable and what's going to be unreasonable in a given case.
Yeah. And Paul, in your experience, and of course, I know this right has just come into effect as of last month, but in your experience in the employment sort of space, which industries do you think will be most impacted by these changes?
Yeah, well, I think difficult to nominate an industry such as, airlines or manufacturing or the legal or accounting or whatever. But what I could say is that it's far more likely to be an impact where the business um, has customers and has customers who are demanding and or whose customers may be in another time zone.
Mm.
So it might be 9 a.m. overseas somewhere, an urgent email sent from a client, and that it is, midnight here. And the um, the client might have expected and or received responses in the past to such communication. The employee might have an alert on their phone, and in the past they've been read and responded to. Now if that changes, um, then that's where a lot of the issues could come about, where the customer doesn't get the contact to what they're used to, and then says, "Well, I'm going to take my business elsewhere," and then the employer comes down obviously hard on the employee, and that's where the disputes are going to arise. So I guess overall, to answer the question, in particular, I think businesses with clients who might be in different time zones, particularly.
Yeah. And Paul, just an extension of that, you mentioned time zones, which is actually another question that we had. So you've addressed that one, but just on how prescriptive is this new law around what constitutes, outside of work, reasonable working hours, right? Is it, is it if someone is on shift, say, and their ordinary work hours are, you know, from 2 in the afternoon to, I guess, 10 at night, or,
Yeah,
those sort of extend into the nighttime or early morning. Is that what constitutes the ordinary work hours? So that means anything outside of that would constitute, the potential outside of working
that's
hours, and
right.
then the right to disconnect would be enlivened. Yeah, okay.
Yeah, it's the normal working hours of that particular employee.
Right. So it'll be specific on a case-by-case basis, right? Because
That's
you can
right.
have
Yeah.
a cohort, a workforce with at least probably could have three different sort of shifts typically, and yeah, it would depend on which sort of shift you're at.
Well, that's right. So you might have a night shift worker who works 10 p.m. till 6 a.m., and then somebody sends them a series of phone calls where the night shift worker um, arguably reasonably puts their phone in another room so that they can sleep because they'll really need it to do another night shift, particularly if the next night shift or the previous night shift was a 12-hour shift. 8 a.m. is contact trying to be made. Well, you can almost say automatically straight away that's unreasonable.
Hi, Paul, can you hear me?
Yep.
Yeah. This is the day. It wasn't even windy today, and we've got all these internet issues.
Oh,
Anyway,
thank.
the question I was that we might just probably just wrap it up. Probably, I'm just mindful of your time as well, Paul. I don't want to delay you that any further. So just one of the questions that we just had around, I guess, the flexibility to sort of say no. So, if the right to refuse, sort of how, I guess, and we'll probably see it play out. This is a new law, and we haven't had sort of much feedback, I guess, as yet from the commission. But how innovative or crafty could the employee be to say, you know what, I'm going to refuse this form of engagement or this communication?
Human nature being what it is, and people acting in their own self-interest, I think there's going to be many clever, crafty responses by employees to get around this. It's my experience though when we're talking about legal things, um, the employees who are not legally trained are making a judgment that is about half or three quarters correct, but they're not getting they're not getting the legal advice. They make a judgment call themselves on what they think the law might mean for them in that particular case, and they go ahead and do something. Again, and that's where the disputes are going to arise when the employer says, "Well, that's clearly not reasonable. You don't know what the law is, and I'm going to take it to the Fair Work Commission." So the employer can take it to the Fair Work Commission too. So it's not like the unfair dismissal jurisdiction where all the applications are going to be lodged by employees. These matters can be initiated by either the employer or the employee
Yeah.
into the Fair Work Commission.
And Paul, would you expect, simply refusing, right, is probably not a very, as we talked about, it's not going to be a serious adverse, sort of incident, but potentially a series of repeated, behaviors could potentially then be considered okay.
Yeah.
This employee is clearly not following. There may be sort of a pathway there for the employee to sort of seek redress.
And the other thing is too is that as per usual, if there's a refusal on the employee's part, it will be helpful if the employee gives some reasoning around the refusal. There might be something going on in the employee's life that the employer is completely unaware of until that very moment where the contact's made and it's not not responded to, and the employee is going through some mental health crisis or some mental health issues, helping a sick relative. Many employers don't know for various reasons many aspects of an employee's life, and so just a blank refusal would likely not go down very well when received by the employer. But if there's some reasoning behind it, then that will help, to get you to some way towards a better reception and dealing with the issue.
Yeah, so I think to your point, to operationalize this, there definitely need to be some integration with your HR and people team to ensure that you are considering the employee circumstances, rather than just taking a blanket view on, what the employer thinks to be a reasonable form of communication outside of working hours or
That's
not.
right. I mean, there's a lot of examples that you could pose. So it might be an example where the employee um, leaves work early one day. Their wife has had a car accident. She's in the hospital. He's gone to visit her. Another employee on behalf of the employer makes contact, not knowing that the employee A left early and B the reason why they left early. They're not answering their phone, and the employee gets in the morning and gets called into a meeting with HR and the CEO and another person, and they think, well, how unfair is that? My wife's in an accident, in that she's in the hospital, and now I'm being hauled over the coals in a meeting. The next morning, I have to explain my actions. These types of things are going to happen.
Yeah, that's right. They're going to happen anyway, whether this right's there or not. Um, Paul, I think we'll just jump to our final question, just mindful of time as well. Given this regime, right, and it's as we've sort of discussed, it's definitely not sort of revolutionary or anything. It's already some organizations already give you this right. Just it's not just enshrined in law, I guess. But now it is. What I guess there are some employers that are going to be concerned by this, right? Because they do want to engage with their workforce at particular times, and and there's probably already been established ways of working, right, up until now. and employers probably might take advantage of this right. So, Paul, the question is, can employers get ahead of the curve by specifying this in the contract or in some procedures or some, employee handbook stating, look, for certain types of work, for certain types of cohorts within the workforce, you will be expected to be available for a few hours here and there, but just sort of setting expectations so that at least it's more transparent rather than being sort of left to the open and at the behest or discretion of the employee.
Well, as lawyers love to advise their clients, if you get it in writing, all the better. If it's in a policy document, if it's in the employment contract, all the better. When these things are not dealt with, and you can't deal with every single thing that might happen in the workplace, but particularly when you've got new laws that coming into place, to put some clause in the employment contract, or even something as minimal as a notice on the notice board, just some information about the situation, then all the better.
Yeah, that's right. That way, at least you make it clear to the employee what the expectations are. There are no surprises. And if you do contact them outside of the ordinary working hours, you can point to something and say, look, this is what we agreed. But I think probably will be useful for those listening on the call that are business, owners or employers, that they do take that approach so that it's clear and transparent with the employee.
And if possible, to get the expectations the same. It's mismatched expectations that particularly creates dispute. So the employer expects certain things to go like this, the employer expects certain things to go a different way, and then when something happens, they act in accordance with their own mismatched expectations, and then bang, you've got a dispute. So that's why really open, honest, transparent communication. Get your employees together. If you've got 20 employees and they're all on, say, one site, get them together for an hour and talk about it with the employer, and let the employees talk about it amongst themselves and encourage questions. So then you can go away and you're all on the same page as much as possible.
Definitely, I think you're right. Without proper communication, you have breakdown in relationship, and that's just an example of what can happen in an employer-employee relationship in the workplace. So, and thank you again, Paul, for being patient during this session today. I know we had a few technical issues.
Yeah, no worries.
The slides on the screen, and I would display Paul's details. Look, Paul's from Law and Lydiard out in Ballarat, sort of services all of Victoria and other states, I assume, Paul.
Yeah, all of Australia, because the Fair Work Act operates nationwide.
Yeah, beautiful. Paul's presented many sessions on Be Informed in the past as a friend of Be Informed. We always thank him for his knowledge and wisdom on these topics. Today's session is, as you know, we have recorded it, so albeit for all the technical issues, I think hopefully it'll come out nicely when I have a look later tonight, and then we'll put it on YouTube so you can watch it at your leisure in the future. There's also a one-page handout that Paul has kindly prepared. So there's the 5 points that he raised today are all captured in that document, and I'll share it with registered participants later tonight. So that brings us to the end of the session. Thank you again for joining. Please do share, Be Informed with your friends and family if you found it useful, and hopefully we get to see you again in the future.
Thanks, everyone, and thanks, Carl.
Thanks, Paul, for your time. Thank you, mate. All the best, guys. See you.
No worries, you too.
Bye, mate.
Yeah.